Hello, I am Attorney Siegfried S. Suarez, the Legal and Compliance Officer of Lamudi, Philippines. Today I will answer the 10 most important questions to ask about land registration, specifically those surrounding unregistered land. The online housing fair and this Q&A serves to guide you in your home buying journey. Be informed, take advantage of the property deals on this housing fair, and enjoy the property of your dreams. This housing fair is being powered by Lamudi. Before anything else, this discussion is only a general overview of the topic. There may be specific particularities in each and every case. This is why we still suggest that you consult a lawyer for your specific land concerns. Now let's get to the questions. The first one is, what are the differences between registered and unregistered land? There is really no definition for what a registered or unregistered land is. However, we take this at face value. Registered land is one which has a corresponding title attached to it in accordance with the legal processes. So the question here is the land registered with the Register of Deeds? If yes, then it's a registered land. But before a land is registered, a land must be capable of registration. It should be allowed by law to be registered to someone. An unregistered land, on the other hand, is one wherein the land has no owner in the eyes of the law. It is not registered with the Register of Deeds. An unregistered land may either be a land which is capable or not capable of ownership. We'll go to that later on. So there are a few things to understand here. Number one, not all lands are registrable. Many people make the mistake in believing that since they have held on to the land ever since they were too young, they are entitled to the land. This is simply not the case. Examples are forest reserves, mineral lands, and previously titled lands. These are not capable of registration. Number two, the certificate of title are proofs of registration. This means the OCP, PCP, CCP. These are just proofs of registration. They have a corresponding certificate of title once your land is registered. But remember, these are not the titles themselves. That's why they're called certificate of title. The government certifies that you have title to the land. And the next one is that a certificate of title, meaning the OCP, PCP, and CCP, have the following features. So generally, they are free from liens and encumbrances, with certain exceptions. Number two, they're incontrovertible and indefeasible, meaning you cannot defeat them usually by themselves. There has to be a greater title. And number three, they are presumed valid and devoid of flaws. So if you look at a CCP, PCP, or OCP, you can rely on them. And again, a certificate of title has a lot of other characteristics, but those mentioned are just some of the important ones. The next question here is, what are the risks associated with letting the land remain unregistered? To put this in context, we are assuming that you have all the right to get a title to the land. There are no impediments. However, we just choose to hold it without registering it. So what are the risks you have? There are so many. So you have to get your land titled immediately. But mainly the following are your top concerns. Number one, another claimant might assert his rights over the land. This is dangerous for you because if another person claims that he owns the land and he gets to the registration first, then you have a problem. The next one would be the government might take the land through expropriation without just compensation due to you. So an unregistered land is usually the one which the government looks for when they make their settlements or look for other lands to use. So again, you have to get them registered because you're in danger of having someone take over your land legally, even if you have the right before. The next question is, what security do you have when your land is unregistered? None. You do not have any security when your land is unregistered. Legally, no one is bound to honor your ownership or title because you do not have any registration or any legal right which is recognized by the government. So you have to register it and register it immediately. But if we force the issue, of course, you will have pieces of evidence which will indicate your ownership over the land. But it won't give you security until the land is registered. These are just evidence you can present, you can show. They are indications that you own the land. But it won't give you the security that you need to assert your rights over the land. So some possible evidentiary items would include tax declarations over the land in your name, an open, continuous, exclusive, actual, and notorious possession over the land, and so on and so forth. But regardless of your evidence, you are very vulnerable when your land is unregistered because the best indication of ownership and the best proof is the certificate of title issued by the Register of Deeds. If you don't have it, then you are vulnerable and you're exposing yourself to big risks. The next question is a big concern for many. What are the costs associated with registering land? There is no template for this. You cannot have a list of costs. You cannot have specific costs. But for better understanding, the following costs are usually involved for any person seeking land registration. The first one would be the application fees. So this varies with the LGU and the court and the geography concerned. So for every geography, there would be differences and variation with the application and the miscellaneous fees. The next one would be technical description of the land, which should be approved by the Director of Lands. So usually you'll have to spend or have to cost the spending for the tracing cloth, the blueprint, which will delineate the metes and bounds of your land. The next one is the survey of the land. This should be approved by the Bureau of Lands, which is now the Land Management Bureau. The next would be the legal fees with your lawyer, because you have to file it and you have to appear in court, and your lawyer has to appear in court. So you have to pay his appearance, his filing fees, and other fees associated with legal help. The next one would be court fees. Every court might charge different fees for different purposes. So for land registration, you just have to go to the regional trial court where your land is situated and you can inquire for the specific costs. The last one would be other administrative fees. In every government transaction, there are miscellaneous fees, there are administrative fees to support and to process your applications. So the fifth question now is, what should you do when someone else is claiming the unregistered land? Now you have a concern because if someone else is claiming your unregistered land, you have to make sure that he has not filed yet with court. If he has not yet filed with court, then you take the first step. You register the land and you go to court. You file it, you put out your evidence, and you take the steps. The second one, what if someone has already filed a registration in court? What can you do? Then you file for an opposition. You oppose the said filing. There is a provision in the law which will support this one. You go to Section 25 of Presidential Decree number 1529 or the property registration decree, it states that any person claiming an interest, whether named in the notice or not, may appear and file an opposition on or before the date of initial hearing. You should file immediately the opposition. But take note of the following items which you should prove in court. This is whether you're filing it as a registration or an opposition. The first one is that you should have proof that the land is alienable or disposable and is registrable. So, what does this mean? You have to prove that the land is capable of ownership. It's not forest land, not mineral land, it's not a military reservation, or any of those sort. It should be one which you can register and own. So this could be done through executive orders of the president, legislative acts or laws enacted by the Congress, among others. Just prove that you can own it actually and it is not a land of public domain. And number two, proof of possession. You should prove that you have been in open, continuous, exclusive, notorious possession of the land for a very long period. So, in the case of Director of Lands versus Intermediate Appellate Court, the Supreme Court held that tax declarations and realty payments, while not conclusive of ownership, are proofs that the holder had a claim of title over the property. So they are indicia of possession. So you have the tax declaration, you have statements from the other landowners beside your land. You can prove that you have possession of the land. Third, you have to prove the identity of the land. What is it that you want to own? What are the borders? What are the ends? And what is the entire area of the land you want to own? So, aside from the tax declaration, again, you can look at the survey plan, you can look at the technical description, you can look at the survey and tracing cloth plan, the blueprint, and a survey done by geodetic engineer. These are the things which can prove the identity of the land. So it's important that you show up to what extent you want to own, and you are asking the court to give title to you. The next question on our list is, does the land registration process differ according to the intended land use? Generally, the answer is no. The process for land registration is similar for all unregistered lands. One exception would be the government housing projects, wherein the government initiates the titling of the land. So in this case, you don't have to go and file anything. You just have to file with the government agency concerned your eligibility for the government housing, and they will be the ones to facilitate the transfer of the land to you. Another exception would be the special laws granting free patents. One of the newer ones would be Republic Act number 10023. Patents are grants given by law to people who the government identifies as qualified to get rights to the land. Patents are not direct title. When you're given a patent, you are given rights to the land. So there are certain requirements which you should comply with before the patent will ripen into a full ownership. So once you comply, the government may transfer the land to you, subject to certain compliance which you should need to continue doing and certain restrictions. So restrictions would be, for example, you're not allowed to sell the land for the first 10 years, and so on and so forth. So in these cases, the processes outlined in the specific laws should be followed. So these are the cases wherein you have different processes from the one which we described earlier. Now you may be curious, who pays tax for unregistered land? Generally, the person who is in possession of the land pays for the tax. That is why we have tax declarations. Because you can have tax declarations whether or not the land is registered. So you have to pay taxes over the land. And these tax declarations are being paid for those which are capable of ownership. You are not supposed to pay tax declarations for forest land, military reservations, because these lands are not capable of private ownership until there is a law or an executive order which will convert such. So you pay tax declaration for an unregistered land, and it is the person who has possession of the land. The next question is related to the previous one. Do you have to pay taxes when you register your plot of land? So you have an unregistered land and you want to register it. Do you pay taxes or not? General answer, no. The process of registration has no major tax incident. There might be little and minor taxes somewhere along the way, but as to the registration, the major parts of it, you shouldn't find any tax incident on it. But just to give you an overview, the taxes mostly associated with land are as follows. Number one, real property tax. These taxes are levied by the LGU to the owners of the property. So this is around 2% of the assessed value. The next one would be the capital gains tax. This is for the account of the seller when the seller sells his land. So a capital gains tax would only arise during a sale of land. The tax here is imposed because there is an assumption that the seller has gained money from the sale of the land. That is why it's called the capital gains. The capital which you've gained because of the sale. This is taxed at the rate of 6% of the sale price. The third one would be the documentary stamp tax. This is the most minor tax in the whole transaction. So, in every documentation involving the sale or transfer of property, you might have to pay stamp taxes. So, this would just run you in the low thousands or even hundreds of pesos. The next question is, how do you determine the value of unregistered land? First things first, you cannot sell an unregistered land. So, for that purposes, don't think there's a value attached to it until it's registered. There is, but you can't pretty much do anything with the land until you register it. The law is basic that you cannot sell what you do not own. So as to the valuation, again, you can put value to it, but you cannot sell what you do not own. But for the purposes of this discussion, let's go to the value. The following things should be considered. Number one, is the land capable of registration? If it is, then the land value will definitely go up. It will be in your favor. Because no one will want to purchase rights only. People would want to purchase something wherein they will have a certificate of title. So assuming you have a rights only over the land, the government or any other private person who might have a better right than you may evict you at any moment. So again, you have to make sure that your land is capable of registration. Then you will have a better value to your land. Number two, you ask yourself, are you the owner of the land? Because if you know that you are just staying in the land with permission from the owner, meaning the owner is just tolerating your stay, he's just letting you stay, and he's letting you use the property. But you have an agreement that you're just someone, you're a tenant, you're just someone there. then you cannot register the land. And you do not have good value to the land because you cannot sell it. So if you are the owner of the land, then you go formalize it. The third one, the status and nature of the land. Can the land be utilized for real estate, farming, development, etc.? If it can be easily utilized, then you have a good advantage. But if you have a lot of things to fix, such as it has so many tall grass, it has so many trees full of shrubs, then you might have to clear it before it can be utilized. The land value would definitely be affected. And another factor here would be, do you have the direct access to the highway? If yes, you're better off because you have access. People can go to your land, go to the land and easily access it. But if you do not have access, you still have to go through other lands, you have to buy other lands, or you have to ask for a right of way, which is costly, which you have to go to court, you have to go to the other people, and you have to ask them. The next one would be the location, of course. Where is your land located? Is it in a fast-growing environment? An example of a fast-growing environment is Clark in Pampanga. Clark is outside of Metro Manila. However, it is accessible by expressway. A railway is also being built to connect Metro Manila to Clark. There is also an airport to Clark, which lands in Clark. So the value in Clark would definitely be a higher one than in other places. Let's say in other provinces and other cities around Pampanga. Related to the previous item, the development also matters. As with Clark, again, big companies have already started investing. We also have hospitals there, the medical city, and others. So with the development and the new population, your land will be more sought after, and people would look to your land as potential for residential or business purposes. The next one is your title clean. So meaning, is your registered land clean rather? When you apply for a title, will you have other opposing claimants? Do you have other liens? So opposing claimants mean, are there other people interested with your land? Other Are there other people saying that that is also my land? If there is none, then good, you have a better value to your land. Are there liens? So there may be liens when you have a title to your land already. Liens are, for example, another person claiming your land, a government note on your land stating that this is limited to such and such. So when you have more limitations, the value of the land will go down. And as to question number 10, how can you make a deed of sale for a land? Again, this will only be applicable to registered lands. You cannot sell what you do not own. So once you have the registration, once you have your land titled, then you can now do your deed of sale. So a deed of sale must be in writing and in tangible form, meaning it should be in a piece of paper or something which you can look at. And it should contain the following: the date of the transaction, the name and information of the seller and the buyer, the description of the identity of the land, and with its technical description. So you have to say this is bounded northwest by this land, this is how far my land goes. Number 4, the agreement between the parties that the seller is selling the parcel of land and the buyer is buying the parcel of land in their own free will. The fifth one would be the purchase price and mode of payment. The sixth one would be signature by both parties. And the last one would be the notarization. The document should be made public. There is no exact wording which you need for the deed of sale. As long as the aforementioned elements are included, you can simply say that seller wishes to sell the land and buyer wishes to buy the land in their own free will, and the land is as follows, and you can sign it, have it notarized, and the price is there. No need for the very long form. You can make it as simple as you can as long as you have the elements written as stated. Now, now that you know the answers to some of the most frequently asked questions about land registration, it's time to turn that unregistered land into a registered land and make full use of it as a value generating asset. What if you want to buy a property with a clean title? The Lamudi online housing fair has plenty of options. And even better, they have exclusive deals that you can get only during the online housing fair. Visit lamudi.com.ph/housing fair and take this opportunity before it ends on May 31, 2021. This has been Attorney Siegfried S. Suarez, the Legal and Compliance Officer of Lamudi Philippines. Have a good day.